Hi, I'm Launi with All Things Divorce and Learn Law for All, and I'm here today with Dr. Kolette Butler. Kolette is going to talk about custody evaluations and kind of some do's and don'ts, and we'll get into more of that when she starts answering some questions that I've got for her. So Kolette is the founder of Verdant Hope. She has her doctorate of psychology. She has her Juris Doctor, and she has her master's in clinical psychology. So she knows what she's talking about. She's really great, and I really appreciate her being here. She is involved. She's a member of the Arizona Association of Family Conciliation Courts for Arizona. She's on the Arizona Psychological Association, and she's admitted to the Arizona State Bar and the U.S. District Court of Arizona. So, disclaimer, as always, watching this video or listening to the podcast does not create an attorney-client privilege or a doctor-patient relationship or attorney-client relationship. We are both only licensed in Arizona, but this information is really useful nationally, really internationally, for anyone who does custody evaluations. It's just some good information to help people understand what custody evaluations are and help them get through it. So welcome, Kolette.
Thank you. Thanks, Launi.
So, okay, so I know I have a lot of questions for you. Kolette and I just did a CLE for Learn Law for All on this, but we wanted to kind of break down some of the things for this podcast. So talk to me about the differences between custody evaluations, limited scope assessments, IPEs, if you will.
Sure. Yeah. So in Arizona, we have 3 different types of evaluations that you might encounter in the family court setting. The most comprehensive is a comprehensive family evaluation. That's what we call them here. Your jurisdiction might call them a custody evaluation, but really that evaluation is the most in-depth, the most exhaustive evaluation that there is for a family. They tend to take quite a while. They have a very broad scope. They tend to be pretty expensive. And at the end, your evaluator can have an opinion about how much parenting time mom and dad should have, or mom and mom, just whatever makeup the family is, and who should have legal decision-making authority, or how much should it be joint, sole, etc. So that's your comprehensive or custody evaluation. We also have something called a focused assessment, and these two, the comprehensive evaluation and the limited focused assessment or focused assessment, these really are considering best interest factors for children. So in our jurisdiction, the statute is 25403. Arizona attorneys will be familiar with that. But in whatever jurisdiction you're in, it would be your best interest statute. Most states have those for best interests of kids. And so we're really looking at what those factors are for the best interest of kids. And a focused assessment, rather than being comprehensive, it's going to be really limited in its scope. It'll focus on 1 or 2 issues, perhaps a mental health issue of someone in the family, substance abuse, abuse allegations, kids' adjustment to a community, different things like that. And then the independent psychological evaluation is really just an individual assessment. So that might be for a parent, it might be for a teen or a child if the court has a question about, the impact or the potential impact of family services on one of the kids in the family. So those are kind of levels.
I do want to add one thing to that. And I maybe should have mentioned it in the CLE too, but one thing that we also have in Arizona is a court-appointed advisor. And this is something a little different. I know you don't do this, Kolette, because they couldn't afford you. But what we have is the court may appoint someone for people who can't afford something more thorough. It's a court-appointed advisor. It's an individual who's received some training and or has some experience in trying to help the court figure out what's going on, right? So they're very different. I haven't seen much structure to them. I think you can get one person to say the sky is blue and the other one to say that it's pink. I mean, I think that they're very different. But if you just have one issue, then you might, have that third party neutral just sort of interview the kids or take something to the court, like looking to see whether the pool is safe or the house is safe or something pretty minor. But some of them do like really thorough jobs, and I know some of them even do give recommendations, and so that's very interesting. I know the one that I know that does, I think she's probably pretty qualified. I mean, she's got some a good background to sort of investigate things and tell the court about them. But yeah, so I just wanted to add that in. That's a court appointed advisor or a CAA. And so when you get a minute entry, Kolette, what do you do? Tell me what your process is right away.
Sure. So if the court appoints me to conduct an evaluation for a family, the first phone call, well, my office will reach out to the parties, send them, intake forms. If I'm doing a comprehensive evaluation, sometimes if I'm doing a limited focused assessment, I'll send out an intake packet that is pretty comprehensive in what it's asking. It's asking all kinds of questions about who lives in the household, how many bedrooms are there in the house, where do the kids sleep? I mean, it's all kinds of things like that. It also goes into intimate partner violence. So there's a lot of questions screening for that, and not just, physical violence, but, financial control or things like that. So paperwork goes out to the parties, and while they're completing the paperwork and the payment and those kinds of things, we're also setting up a call with attorneys. For me, I like to talk to the attorneys, and if one of the parties is pro se, they are included in that attorney call. And really, that's just for me to learn what are the critical issues that are sitting in front of the court. How can I make this evaluation the most useful and the most valuable in helping the parties or helping the judge resolve this case? And sometimes in that initial phone call, we realize that a focused assessment isn't going to be adequate, or we realize that, an independent psychological evaluation of mom is not going to yield what you're wanting here. Let's do a focused assessment of both parents or the mental health of the kids and the parents. But just an opportunity to talk to the attorneys about what the salient issues are in the case.
Now, what if one person's not represented or both people aren't represented? Does that person sort of fill in for the attorney, kind of? Do you just call, like, if mom's not represented, you would call dad's attorney and then mom?
Yes, that's right. So if you're pro se, you're going to be included in that call. Sometimes I think pro se litigants feel in over their head a little bit. And so I'm pretty directive in that call about what do I want to hear from you. I'm also very clear that I do not want you litigating your case to me, that I am not the judge and we are not here to litigate issues. I really just want to know what from my report, why did the judge ask me to do a report? What from my evaluation is the judge hoping to learn so that this case can move forward?
Yeah, that's interesting. Because I think a lot of people do try and litigate their cases, I'm sure, to you, because and you should have everything so that you can know exactly what to tell the judge, right? So then what can people do to prepare to make sure that they're not litigating their case to you, but also to make sure that they're providing you with what you need to, make an informed, judgment?
Sure. So in advance of that phone call, I think perhaps looking over some minute entries, what is sitting in front of the judge? What's the next decision the judge needs to make in your case? Is it making a determination about parenting time? Is it making a determination about legal decision making? Is it making a determination about the safety of the kids or supervised parenting time? So like, what is sitting in front of the judge that prompted the judge to want additional information? So really preparing yourself with that, and then coming into the phone call with, here's what the judge is wanting to know in this case. If your report can cover this, that will be helpful to the parties.
Yeah, and I mean, do you limit the amount of documents that they can give you? I know some of the other mental health professionals do limit. They say, you know, you get 10 emails on each subject or something.
Yeah.
Do you do that also?
Yes. There's no way not to.
Yeah, and especially when there's a pro se, right? Because then you're going to have everything and the kitchen sink.
Yeah. Yeah.
Then if you look through it and you're like, okay, yeah, you can give me more on that or more on that, do you kind of allow them to do that?
Yes. Yeah. If there's an exchange that I think is really highlighting a dynamic that I've seen pop up in other areas, then yeah, I might say something like, hey, send me more of this communication, just so that I can really nail down a pattern that might be happening in other areas, but is illustrated well in that email exchange or that text exchange.
So, you know, I'm sure you get this question when you have a pro se on the other side, or at least this fear that you have this relationship with this other attorney. And I think the minute entries typically tell you that you can't have ex parte communication, right?
Yes. Yeah.
So that's not something that they should worry about, because and you know, one of the things I always told my clients was, look, you know, Dr. Butler or whoever is not going to throw away their career because they're friends with an attorney, you know, outside of you know, their profession. Maybe they've had drinks a couple of times. They're not going to throw away their career, because probably because I think when I do my stuff, I'm not even thinking about who the other parties are involved. I'm sort of thinking about what's right in front of me and the facts, and you don't even necessarily think about who that attorney is on the other side, right?
Yeah. Yes, for sure. I mean, I think you captured it really well. We have professional and ethical duties. Most of us care deeply about those. We've devoted our lives to this profession. In addition to that, I think when I am considering an attorney, sometimes the only thing I'm considering in that setting is how well do I know this attorney works with other people? So it's not even about who they are as a person. I know at the end of the day, you know, we'll see each other at a conference and we know that we were working a case and we were doing our job on a case. And so, you know, that just is what it is. But one thing that I do think a lot about is, how does this attorney conduct themselves, him or herself, in this phone call? How are they doing in terms of being collaborative? Are the attorneys high conflict, right? Because that is a factor that we look at when we're looking at high conflict families. And so, you know, and how are they doing with a pro se litigant on the other side? It's hard to be an attorney and to have a pro se person on the other side, because you're kind of advocating your case and also doing a little bit of education to make the case go more smoothly, right? So it's a little bit tricky.
Yeah, I had that conversation with Dr. DiCarlo a couple weeks back on our podcast, and it was interesting because, you know, first of all, you know who are the difficult attorneys, I think, in a lot of cases. But also, it's like, you know, we could screw it up as attorneys. We can make stuff worse, because part of our job is to advocate for our client, and our client might be perfectly fine with every other weekend and one night a week. But, you know, you get an attorney who's like, no, you have every right to have 50-50, and you should get 50-50. And the person might say, no, I'm totally fine with her or him having, you know, sole legal decision making, or at least final say, because they've been making all the decisions anyway, blah, blah, blah. And then you're like, well, no, you have the right, you know, and we as attorneys are, you know, walk this fine line where we want our clients to at least know what they can get or what is likely to happen. But on the other hand, there are some attorneys that just push it so hard, and it's like, just, you're screwing up the kids now. You just let these people resolve this issue by themselves.
Yeah.
So what else, and you and I talked about this in the CLE, what else can someone do to get ready for the evaluation? And I think you and I talked about people who are like victims of domestic violence or who have had some significant trauma and really need to kind of pull themselves together, because it could be a very difficult process.
Yeah, it is a difficult process. Whether you are being independently evaluated or your family is being evaluated, it's intrusive. One of the things we were talking about in the CLE was the records that are reviewed, and behavioral health records are reviewed. So that's your therapy notes, all of those kinds of things. You certainly can object to producing those. I don't think in general it looks good for you to do that, right? And so it's tricky to come to terms with all of that. And I think just recently, and Launi, you may know this better than I do, but I think just recently there was, I think, an appellate case on the issue of therapy notes, and that that the privileged aspect of those was really being honored, and only portions of notes that pertained to the substance use or something like that were ultimately produced, but all of the rest of the stuff stayed back.
Yeah, I vaguely remember that. I think one of the things
I think
that
Helen Davis was on that case.
Who was?
Helen Davis, I think. And I
Yeah,
think
that kind of sounds like a Helen Davis thing. She's kind of
but
not in a bad way, but
yeah, because as a therapist, like working in the forensic realm, I am, well, being an attorney also, I'm super mindful of what I put in my notes, but not every therapist is. And like, then all of that goes out into open court, and like, what a nightmare.
yeah, I mean, the one thing that we do if that happens, because sometimes they'll just refuse anyway, and yeah, it doesn't look great, but they don't have to legally,
Right.
supply them, but you can ask the court to make a negative inference about what was in them.
Yes.
And that's kind of where you go from that, because it's really hard, especially for someone who's wanting the evaluation for someone else, and all their crap's coming in, and then you're holding all your stuff back. I mean, I think you just at least ask the court to make a negative inference, but I mean, they'll just never know. But yeah, they don't have to, but they, if
it is a risky move. Yeah.
Right. Yeah, very risky. I think you have to, assess with the importance of that.
Yeah. So sorry, I got a little bit off of track there, but I've worked with a few survivors of domestic violence, and part of what came out in the evaluation was their therapy notes, where they were talking about the violence and the trauma and the abuse. I think one of them, even her notes from EMDR, and those notes are not meant to be extensive. Like, as a clinician, you're not meant to take lengthy notes on that, but all of that kind of got into the court, and man, that it was like her reliving it all over again, right? So when you're going through this process, get some really robust support in place, whether it's friends or family, or get a therapist, whatever you need to do to have support, because even just filling out the intake packet can be overwhelming and super emotionally charged. And you really need your thinking cap on when you're going through that, and you need to be able to attend to detail. But the way that our brains work when we're flooded out by emotion or when there's trauma is, we just don't do our best work there. And, Launi and I will have a CLE on trauma that you can check out to kind of learn how to work with that more. But get the support that you need to be able to go through this process, because it is going to be tough, and it's going to be longer than you want it to be.
Yeah, and I've helped people fill out paperwork, and I've if I've helped them fill it out, like after they've already filled it out, there's times where I'll see just some big errors, especially victims of domestic violence making excuses for their abuser or not putting something in there. I actually had one case where the woman, we didn't have an evaluation, but we were doing a modification, and she had been severely abused, ended up in the hospital several times, never even listed that on her petition when it said, has there been domestic violence? Because one, she was from a country where that was permitted. And two, she thought that since this was about the child and not so much about her, that she didn't write it down. So it's important to really write down the abuse. It's important not to make excuses like, well, he did this because I did that. No, he did this, period. You don't have to say why he did this. You're making an excuse for him. So if your ex or husband or wife or whatever pushed you, your ex pushed you, not because you took the remote control, but your ex pushed you on this date. And I have them do that. They can get more out, I think, to you. But when you're limited on word and space, I at least want you to get all the abuse out. So is that like a fair?
I think it is. And I think, another aspect of that, if someone says, he hit me, but I deserved it because I took the remote, I think that's a real window into what the dynamic is, what the power differential is. And so if I am offering any kind of recommendations to the judge about legal decision making, then I'm saying like, no, like there cannot be joint legal decision making in this case because she thinks she deserved to be hit for picking up the remote, right? And so, there can be some value in that. And part of that is for the evaluator to suss out. And I think also if your client says that, it can be a really beautiful window into like the dynamic.
Yeah, that's a great point. But if you have, say, limited space, would you rather know of the 5?
Oh, yeah. Right.
And that's kind of
because then in the interview, you follow up on that.
Right. And that's what I usually have them do. And I always tell people to take notes in with them. Are you okay with that?
Sure.
Make sure that they're addressing everything.
Yes. People can bring notes in. Just kind of my policy is you can't leave anything with me. So any documents that are coming to me must copy co-counsel or the other parent. And there needs to be a record of that. So I don't accept any documents physically in my office.
Yeah, that's okay. So that's great information for people to have. So let's go to the 5 do's and 5 don'ts. And I think we had talked in the CLE, and I said, I always tell my clients, be on time, be respectful of the other party or of the evaluator staff, just take the whole thing seriously. And so like I have them, map out the day before if they're going to be in person. If they're not going to be in person, I have them turn off and on their computer like an hour ahead of time, because it never fails that, all of a sudden your Zoom needs to update or your computer's going to shut down and restart. So restart it at least an hour before your meeting time if you're meeting online. And if you're not meeting online and I always say be at least 15 minutes early just to account for some traffic. So would it give me some do's?
Yeah, I think those are really great. I think also being thorough. So that goes a little bit to your questionnaire, your intake thing. Be honest. The truth is likely to come out anyway. It's much better if you tell me the bad stuff than that you kind of sugarcoat it and then I find it in documents or I find it in a collateral interview. Then it doesn't look great that you were sugarcoating it or hiding it. For sure, how you interact with my office staff can come into play in the evaluation. It can be suggestive, or it can even be evidence that illustrates certain pathology. If certain pathology popped in your psychological assessment, part of my data set is how you interacted with my office staff, right? Be accountable. If you made mistakes with your co-parent, if you made mistakes with the kids, own that. Tell me what you learned from it, how you're doing it differently now. All of that is super helpful. No parent is perfect. Don't try to pretend that you are.
Yeah, and I'm a big fan on having people get help when needed. So, and this is something we didn't talk about in the CLE, and something you probably weren't planning on me asking you now. But if somebody's got some domestic violence charges or allegations, as an attorney, if you've got a 6-month window between when you're hiring an evaluator and when you're not, and when they're going to have it done, that's a lot of time that you can rebut some presumptions. And in Arizona, one of the presumptions, a way to rebut the presumption that sole legal decision making or joint legal decision making wouldn't be in the best interest of the child, is to take some classes, some anger management, some domestic violence classes. So would you recommend that if somebody, if there had been some domestic violence, whether it was situational or chronic, or however you guys, the big D or the little d, of domestic violence, would you say go ahead and take the classes because now you've addressed that?
Yeah, I would say do that. There may be other evaluators who wouldn't, but I think sometimes a parent's concern is, well, if I go take the classes, aren't I admitting that I did the thing? And that's not how I would view it. I don't think that it's like evidence that you did X behavior. I think what it demonstrates is that you're taking seriously the concerns that your co-parent has expressed, and your co-parent is a critical part of your interactions with your co-parent are a critical part of your parenting, frankly, right? Like
Yeah,
the
I think for
biggest
me,
impact of the kids is there conflict between you and your co-parent, right?
yeah, and I think for me it was like, look, there's a rebuttable presumption. Start the rebuttal right now, because what would you tell them to do? And if you said, okay, there's allegations against domestic violence. By the way, I don't know, an attorney may tell them to just take the fifth because they don't want to admit it in there. Because maybe they have an upcoming court case, for whatever reason. But if you do believe that somebody's committed domestic violence, do you have them then in your recommendation, do you say mother or father should take this 26-week in-person course?
Yeah, if there's enough data that suggests more likely than not that they perpetrated some kind of violence, then yes, part of my recommendations is going to be either therapy dealing specifically with domestic violence or taking classes or something like that. So yeah, why not get a jump on it?
And that's kind of because if it's done, if your recommendation was, okay, mom or dad needs to take these 26 hours. I know in California they require 52 hours, but in Arizona I think it's typically 26, right?
Yeah, I think depending on what services you're using, yeah.
So if you take it, then it's done, and now you're moving forward with your parenting time, because now you've already fulfilled one of the evaluator's recommendations, I guess, in my mind, is kind of how I look at it.
Yeah, and then I think I would add like an asterisk to that, and it would be if in the interview with me they're saying, oh yeah, I did this class, and I say something like, oh, well, tell me some of the things that you learned, and they're like, well, didn't really apply to me, da, 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 da. I'm going to recommend that the judge order additional something, because they came out of this like learning nothing, right? So I think if you're an attorney advising your client about that, they really need to go in and like come out with something.
That's a great point. Yeah. So if you do take the classes, make sure that you learn something, and that you can, teach it back.
Articulate that. Yeah.
Yeah.
Right.
So what are some don'ts? What are some don'ts? Like, what should somebody just absolutely not do?
I think minimizing the conflict they've had with the co-parent, or I have seen some really horrendous text messages between co-parents before. And, if you're minimizing that, instead just own it and just say, yeah, I wouldn't talk that way to my worst enemy. That was really bad. I can understand why I did it. I don't do that anymore. Just like, so again, be accountable. Don't minimize or pretend that stuff is okay. If you can, don't be rigid. Don't come in with one certain idea about why all this conflict is happening, right? Oh, like 100% it's my co-parent, and of course the kids don't have a relationship with him because he's so harsh with them, and da 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 da. Rigidity is not helpful, and it doesn't reflect well on you. Don't be perfect. I had one gal come in. I always ask, what do you do well as a parent, and what could you improve as a parent? And one gal came in, and when I asked, what could you improve as a parent, she paused for minutes and then said, I don't think there's anything I can improve on. And I mean, that's tragic, right? It shows poor insight on her part. And, how is that going to be beneficial to her parenting or to her kids? There's no such thing as a perfect parent. Don't try to pretend that you're perfect. Don't lie. Don't scapegoat your co-parent for everything. So I think those are probably some of the big things.
Yeah, and I tell people, for sure the don't just blame the other parent, like accept some responsibility. I think that's important. And don't just generalize. Don't just say, he's a terrible parent or she's a terrible parent, or she's borderline or he's narcissistic, or don't just say these things. Provide facts. I think providing facts are really important, and I think help Dr. Butler and any evaluator understand really what's happening. So if it was like, if your experience was that, say, dad came home and he expected you all to greet him at the door, and if you didn't greet him at the door and welcome him home with hugs and kisses, he would be super pissed off. That's a better fact than saying, he's a narcissist. If there's something, and that's one of the factors that go in there. I always tell my people to go look at the factors, do you have any facts that if one of the factors is lying, okay, let's talk about the lying. You don't need to go through, but they need to understand what they need to provide you with, what information is going to be relevant to you. And if providing you with information that sort of shows what their issue is, I think is more helpful than them saying, he's bipolar.
Yes. Yeah, it's so helpful. If somebody can give behavioral descriptions, it is worth so much more than coming into my office and saying you read a book about covert narcissists and that's what your spouse was. That is not super useful to me. I then have to spend a fair amount of our time asking all the questions, right? But if you come in with behavioral descriptions like the ones you pointed out, that is super helpful. And it puts you in a better light, right? You're not out there pretending to be a clinician or a diagnostician. Right. You're saying, this is what it was like to live with that person, or this is what I observed my kids responding to in my co-parent, all of those kinds of things.
Yeah, I agree. I think that I always like my clients to provide facts to me anyway. I'll always say, they'll say, oh, he was just terribly abusive. Okay, what did that look like? Mm-hmm. Tell me what that looked like. Well, he would yell. Okay, talk to me about when he would yell, and really have them break down the facts. Well, I love for them to tell, some story to you, right? I mean, if they have room or time, right, you want the story behind it. I, did this and he had told me not to, so he pushed me, or he walked very rigidly, quickly next to me, knowing that his shoulder would go into my back and I would fall forward or something like that, but then said, oops, sorry, that was a mistake. Those are some things that we try and get people to do, so that they're really providing what that looked like, what the abuse looked like, what the substance use looked like. You're saying somebody's got substance abuse. Okay, well, are they falling down drunk? Are they drinking 2 glasses of wine? I mean, look, if I'm a person who is super religious and says no caffeine, no alcohol, no nothing, then one alcoholic drink or one Diet Coke or one, Starbucks coffee might be excessive to me.
Mhm.
But I may also come from a family of alcoholics. And so, 4 glasses of wine a night is not a big deal. So what does your issue look like? Because it's going to depend, I think, you need to be more specific than he drinks a lot or she drinks a lot, right?
Yeah. Yeah. And if you can capture some of the conversations, and I don't mean record your kids, right? So some parents do that. I think there's mixed advice about that out there.
I think we should have a whole podcast on
Yeah,
that.
we probably should. It can backfire, and it can be really hard for kids when they find out that they've been recorded. It really destroys trust. But if you can capture substantively, like, mom said this, child said this, mom said this, child said this, right? Just to give like a flavor of, this is how mom is responding when the child is saying these things, that can be really helpful, right? Because as an evaluator, I will go into the home for many evaluations. And I try to spend a lengthy period of time there, like 3 or 4 hours, because anybody can hold it together for an hour or two. And I do require the parents to do like tasks with the kids where they're teaching them a new game or they're cooking with them. So I try to draw out frustrating experiences on purpose. And most people can keep it together for a couple of hours. But by the time we're in the 3rd or 4th hour and the kids are doing whatever, sometimes those dynamics will emerge, but sometimes they won't, right? So if you can capture some of those and share those with me, that's helpful.
Yeah, one of the things I recommend for the evaluations is if parents, like, one, don't make it the first time you're cooking with your kid. Practice, practice, practice. You don't want to, have your kid cracking an egg for the first time, at 6 years old and making a mess all over. And then I love having them make pizzas together, because I feel like that's something that's so fun that they can do, that the kids like. And also choosing a food that the kids like. Let's set them up for success, right? Let's set this whole evaluator visit up for success. Whatever you need to do to, you set it for after they've taken their nap. You set it for,
Yes.
something that you've done with them before. If it's dinner or lunch or whatever, if maybe you're going to make a big sub sandwich, do that once before. Make sure they like it. Make sure they're not disgusted by it and throwing a fit.
Yeah.
It's just important to me. It's like, let's set them up for success. Let's make some cookies afterwards. Let's do something that's super, even if it's just the chop up ones and you throw them in the oven. But I'm a big believer in setting up for success. Now, what are the biggest problems that you find in a home? Like when you're doing your check, is there some specific thing that you look for that you're like, ooh, if I find it, I'm nervous, like a gun that's not locked up? Or
For sure. So safety stuff is probably like the biggest red flag thing. So most evaluators are going to go through your house, including like your cupboards and your refrigerator. And I always have the kids take me on a tour, because they're going to show me all the stuff, right? And so if a kid is saying like, oh, and this is where, the guns are and whatever, like, okay, is it locked? Is it up high where they can't access it? All of those kinds of things. Or, other safety concerns, like under your kitchen sink, are there child locks on the kitchen cupboard? And is there
so what
poison
age should they have
accessible?
locks on the kitchen cupboard?
Oh, I don't remember what the guidelines are, but I would say any kid under the age of probably 5.
Yeah, see, my kids would have been taken away from me.
Well, and I don't know, but the kid needs to be able to like recognize and be like, I'm not going to go get into that. Maybe under 4, but for sure under that. And then, other like age appropriate things in the house. So safety is always kind of the first thing that I'm looking for. And then I'm looking for, functionality of like Does the bathroom sink work? And is there soap at it? Does the toilet flush? Right? I mean, like, is there functional stuff in the house? Can the kids reach snacks or water if they need it? Those kinds of things. What is their own space like? I had one kid show me their closet. They like opened it up. It was beautiful. It looked like a rack from Target. And they're like, oh yeah, these are all new. I've never worn these before. I was like, yeah. Okay.
Yeah, I also tell my parents to do their shopping or do their cleaning at least a month ahead.
Yeah.
Like, at least, because you don't want the kid to go, look at my room and look how clean it is. We just cleaned it last night. Or
Yeah.
Look
This
at
is
my
a brand new
clothes,
bedspread. I never had my own sheets before.
Right.
Yeah.
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 You want those worn in for like a good month before
Yeah.
those ones are there. All right. So,
Yeah.
all right. Well, thank you so much. I think this is really helpful information, and I'm sure, lots of people are appreciating you kind of talking about this stuff. And I hope that you'll come back. And I do think that there's probably 5 more podcasts that came out of this conversation. So thank you so much for being here.
Of course. Thank you.